The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. Before we get started, I just want to make sure that everyone on the webinar can hear us okay. If you can please just raise your hand using the hand icon. That'll let us know that our sound is working properly. Thank you. Now, if you could just lower your hands so that later on we don't call on you by accident, that would be helpful. So welcome and thank you for attending the State Board of Nursing's stakeholder meeting via webinar today. Before we get started, we would like to introduce the staff members from the Division of Professions and Occupations that are present. My name is Elena Kemp, and I am a regulatory coordinator with the division. Also attending is Karen McGovern, the Deputy Director of Legal Affairs, Jenny Albert, Senior Program Director, Roberta Hills, Program Director, and Laura Bravo, Policy Analyst. In compliance with the Governor's orders regarding COVID-19, the division has transitioned to a platform that is 100% virtual, and we appreciate your flexibility. As many of you have been to DORA stakeholder meetings before, we would like to reiterate the importance of your comments today. DORA makes decisions every day that may affect your life and your business, so your input is vital in the rulemaking process. Throughout this process, our goal is to create regulations that clarify and explain legislation, ensure minimum competency to enter and continue to practice, and to provide what is absolutely necessary for consumer protection without creating unnecessary barriers to the marketplace. Your input will be part of the information that goes to the board as it considers adopting revisions to the rules. More specifically, today we will be discussing the implementation of Colorado House Bill 1216. That's the sunset review, which continues the Nursing Practice Act. We'll also be discussing Colorado House Bill 201183, the sunset review that continues the certification of nurse aid. Colorado House Bill 2013-26, that creates an occupational credential portability program. And Colorado House Bill 2102, that concerns disclosures that providers have to are going to be required to provide if they have convictions of sexual offenses. So this meeting is being recorded and will be posted on the website at a later date. As this stakeholder meeting is solely via webinar, please raise your hand if you would like to speak and we'll unmute your line. And the way you can do that is, like you guys have seen already, you just click on the hand icon, or you can type your comment in the question section and we'll read it aloud. For anyone that is planning on providing comments, please state your name and who you represent. Feel free to provide either general comments on the rule changes or specific comments on the proposed language. We are planned to have a couple of hundred attendees during this stakeholder meeting, so please keep your comments limited to 3 to 5 minutes or less. And try not to repeat something that was already said. Stating you're in full agreement with someone else works fine, and it will be noted. If you're using audio through your computer, please remember to put your phones on vibrate or turn them off. And whether or not you're using audio through your computer or on your phone, try to keep background noises to a minimum when speaking. Before we start taking comments, Karen McGovern will provide an overview of the legislative changes that we'll be discussing. And Karen, I'll turn it over to you.
Okay. Good afternoon, everyone. We have a couple of legislative changes to talk about today. Wanted to just reiterate that this is what we call an early stakeholder engagement meeting. And what that means is that we are bringing to you the legislative changes and getting your feedback and your input before we take that information to the board so that they can make determinations about how best to implement these these changes in the law. So I think sometimes there's different kinds of stakeholder meetings, and sometimes we hand you the draft rules and you can make comments on those. Today is the early meeting, which means we want to get your input before the board figures out what rules or what changes need to be made. So keeping that in mind when you're making comments is just, we want to know about how how the changes impact you, what you think could be helpful in the rules, and those types of things. So the first bill I want to talk about is Senate Bill 2102. This bill is called Provider Disclosure to Patients Regarding Formal Actions Based on Sexual Misconduct. This bill affects all healthcare providers that are subject to the Medical Transparency Act, which that means all licensees that report to the Health Professional Profile Program, which includes all licensees of the nursing board, including certificate holders. So nurses, nurse aides, advanced practice nurses, psych techs, everybody regulated by the nursing board is subject to this new law. And what the new law says is that a licensee has to provide written disclosure to their patient of any final conviction or a guilty plea for a sexual offense, or any final disciplinary action that was taken due to a conviction or guilty plea to a sex offense, or findings of unprofessional conduct that were related to sexual misconduct by the licensee. So that means any nurse, nurse aide, APRN, practical nurse, psych tech, who is disciplined by the board for sexual misconduct and is still on probation will have to provide a written disclosure to their patients before they treat them that says that they've been convicted of this offense. The patient has to read the disclosure and sign the disclosure agreeing to treatment. That same requirement is for anyone who has a conviction or a guilty plea to a sex offense and they are currently serving a probationary term with the courts. The law requires that the board make a rule about that and that they provide a sample disclosure form for professionals to use. Any licensee or certificate holder that fails to comply with these requirements can be disciplined for unprofessional conduct. So that's the first bill that affects a huge amount of boards within the division. The second one is House Bill 2013-26, and it creates occupational credential portability. So essentially, this will take over for what we used to call endorsement. An endorsement is when a nurse who may be licensed in another state, and this is separate from the compact, a nurse who might be licensed in a single state wants to be licensed in Colorado, she can apply, or he can apply, and ask to be brought in through endorsement, which means because another state approved your license, then Colorado should approve it. This takes the place of that and just makes sure that we're streamlining that process and not putting unnecessary burdens in applicants' way. This law also allows military spouses to obtain a 3-year temporary credential for any profession or occupation under the division if they hold a credential in good standing from another U.S. jurisdiction. So same scenario, if my husband gets transferred here on military orders and I'm a nurse in another state, I can come here and get a 3-year credential at no cost during the time that my spouse is serving in the military here in this state. So those are the two bills that overarchingly affect many, if not most, of the professions in our division. And I'm going to turn it over to Jenny Alber to talk about the changes that are specific to the nursing board through the Nurse and Nurse Aid Sunset Acts.
Hi, thank you, Karen. Hi, everybody. My name is Jenny Alberg. Good afternoon. I'm the Senior Program Director here at the division. There's an awful lot in here, so I'm going to kind of hit some highlights of what we think, so you guys kind of all can hear what the changes are going to be, and then we can certainly go through it in more detail and get your comments, so that we can obviously make the changes that we need to make rule-wise. So the largest change is that the Nurse Aid Practice Act has been folded in to the Nurse Practice Act. So going forward, the combined act is now going to be called the Nurse and Nurse Aid Practice Act. There are several changes to the requirements. Specifically, there's now an articulated plan, or let me go back, sorry. The articulated plan requirement for APRNs seeking prescriptive authority has been removed. The number of mentorship hours required to obtain full prescriptive authority was decreased from 1,000 to 750, and the age requirement for volunteer nursing license was removed. An applicant no longer has to be at least 55 years of age or older in order to obtain a volunteer license. The laws definitely changed some definitions and made administrative changes. And for the most, I can go over the big ones. Advanced practice nurses are now advanced practice registered nurses, so APRNs. The bill defined collaboration, delegation of patient care, plan of patient care, and licensed healthcare provider, and expanded the definition of the practice of practical nursing. It also removes the requirements of the program of a DPO consult with the board when appointing an executive administrator, and that one member of the board serve on the panel to interview candidates for the position. There are numerous updates that were related to discipline. The board can now enter into confidential agreements with nurses who have a physical illness, physical condition, or behavioral or mental health disorder. Malpractice insurance companies are now required to notify the board of any malpractice claims against a licensed nurse. Nurses must now report a conviction of a crime within 30 days. It used to be 45 days, so that's been shortened. The bill removes a requirement that certain conduct by nurses be done willfully or negligent in order to be subject to discipline. And finally, the bill modified the grounds for discipline related to alcohol and drug use, diverted controlled substances, failing to report certain actions to the board, failing to act within the limitations created by physical or mental illness, failing to comply to limitations agreed to under a confidential agreement, and engaging in a sexual act with a patient during the course of care or within 6 months of care. So that is the nurse portion. For nurse aides, there was 3 main substantive changes. First, after a certificate is revoked, the waiting period for recertification is now 2 years. Second, if deemed competent by a registered nurse, CNAs may now expand their scope of practice so they can change ostomy bags, administer oxygen, and place medication in a minor patient's mouth if the medication was prescribed by the minor's, let me get the right wording here, if the medication was pre-sorted by the minor's parent or guardian. And then finally, the bill also clarified that the regulation of a certified nurse aide does not apply to a person directly employed by a medical facility for the first 4 months of practice. So if the employment is part of an approved training program and the certification is not through endorsement. Okay. I know that's a lot to kind of take on. That is the overview and highlights of the bill.
I think, Jenny, a good place to start would be to just kind of break those changes out and see who has comments on sort of each area.
Yes,
of the
ma'am.
changes, and
Yep.
then taking comment that way might keep it a little more organized.
Yep. I was getting to the top of my screen. Sorry, guys. I think that, yeah, the easiest, let's start with the big stuff. So if there are any comments on the articulated plan, requirement for APRN seeking authority was removed. You can start with that. We'll kind of go through these one by one.
Thank you, Jenny. I have a comment from somebody that sent a question in. Colleen Casper has a couple comments. I'm not sure if we're on the right section though. Should I go ahead and read them?
Sure, I think that's fine.
Okay. Okay.
Probably easier.
She said, yeah, on the downloadable documents on page 19 of the 2 pages, I have questions about item F and APRN. Is it confusing to include the statement? Maybe she's typing something else. Colleen, I could also unmute you if you'd like to speak. That might be easier. I'm going to go ahead and unmute your line. You're now self-muted. If you want to speak and explain your comments, feel free to.
Thank you very much. So good afternoon, everyone. What a lovely day to do this, Friday at 3 o'clock. Anyways, one, it talks about the advanced practice registered nurse, once they obtain full prescriptive authority, is not required to maintain or update an articulated plan. Does this need to be in there? Will it be confusing? Is it in the statute, or is this, I was going back and forth between statutes and rules and trying to make sure that we're as clear as possible. That the articulated plan there's some confusion in the community as to whether the articulated plan is required until prescriptive authority is achieved. So I think that's a question that I would like to have clarified. Thank you.
Okay.
Thank you. That question will be noted for the board. I'm not sure if Jenny or Elena are taking notes on that, but
Yes.
we'll have that noted for the board to consider.
Hi, Laura and Jenny. This is Elena. I just, as we go through these, it might be helpful for me to take notes if I know the rule or the area of the rules that these changes would be potentially made in. So then we can capture comments and questions that way.
I agree, Elena, but I think if you can just keep a running total of the comments, then we can go through and add them in the appropriate place in the rules.
Okay.
Thanks, Karen.
I have a hand raised from a Karen Zink. Karen, you're unmuted.
Hi, this is Karen Zink in Durango. Thank you for doing this. I really appreciate the opportunity to hear the discussion. I'm curious about one thing. Do all of the professional practice acts have that same requirement that there's no sexual activity with the patient for 6 months after the last encounter? And if not, why did this get put in nursing? I'm just curious about the concept. Thank you.
So this is Karen McGovern. Not all practice acts are written like the Nurse Practice Act, so there are varying laws regarding that concept. This is something where this is a law that was passed by the legislature. It wasn't just for nursing. It really does impact nearly every health profession, including professions that aren't traditionally considered healthcare, like athletic trainers. And the intent of the law was to make sure that patients or clients are notified if their provider is currently being supervised for sexual misconduct or a criminal sexual offense.
The one I was talking about, though, is the no having sexual encounter for 6 months after the last patient visit. I'm just curious where that came
from. Where that came from, the change in the Nurse Practice Act.
Mm-hmm.
There are other professions that have that, and it's to make sure that professional boundaries are maintained obtained, and typically they will add a time frame or make it more clear when some people don't understand or feel like the guidelines are vague.
Okay, thank you.
Thank you.
Okay.
I have a question or a comment from Jennifer Zahn. Jennifer, you're unmuted.
I'm sorry, I didn't mean to unmute.
Oh, okay. I can lower your hand.
Sorry about that.
Thank you.
Okay.
No worries. Thank you.
Okay.
I don't see any other hands, and I have no other questions at this time.
Okay. The one thing actually I do want to point out to everybody so that they're aware that this is a summary of the changes. The law is already, it's done, it's written, it's signed. What the board is here to do and what they will do is take your comments, and we're looking at how we implement that law. So unfortunately, I mean, so I just want to make sure that everybody's on that same understanding that what the board does is we're part of the executive branch. We implement the law. We cannot change it. Aaron or some of the other staff possibly can help us answer the questions that you just had, about what was the intent. Unfortunately, I can't answer that, and I don't think the board can answer that because, we're not in the Capitol when they make those decisions. So you have to just kind of bear with us on this. So the next big section for Elena and for everyone that's listening is the mentorship hours. To receive full prescriptive authority was just decreased from 1,000 to 750. And on this one, I am curious if there are any comments or anything you would like the board to think about or hear or moving forward.
I have a couple of questions that were sent out. One is just a logistical question. Shannon Seacrest asked if a link to the recording will be sent out afterwards. And I believe, Elena, correct me if I'm wrong, a link to this recording will be posted on the board's website at a later date, correct?
That's correct. If you go to the Board of Nursing's webpage, it'll be under public notices, and there will be a link there for the webinar recording.
Thank you. And then Holly Fast asked, what is the time frame for implementation of the new laws?
Well, nope, go ahead. Sorry, Karen.
You can go ahead, Jenny.
Well, what I can tell you is we are looking at, and I may have my dates off, I think in the next 2 weeks, we're going to be presenting draft rules to the board in a full board meeting. Then we will come back and we plan to have 2 more stakeholder meetings because we want to make sure those will be in September and October. And I don't believe the dates are totally nailed down just yet, but we will have them on the calendar, on the DPO calendar and on the nursing board webpage calendar in an effort because we want to make sure that we are hearing everybody's comments, everybody's concerns, that everyone is kind of on the same page. And then I believe they are being, Karen, maybe you have to help me out here on the date that we are actually doing the rulemaking hearing. Can I find it?
The rulemaking hearing is tentatively scheduled for October 28th.
Thank you very much.
You're welcome.
Great. Thank you, Jenny and Elena, for answering those technical logistical questions. Colleen Casper has a couple questions, including regarding section 1.14 of the rules. Colleen, I'm going to go ahead and unmute you. Colleen?
Hi, thanks again. So this rule has to do with written agreements and general authorization. It looks like it has something to do with specific to pharmacy and APRNs. And I just wanted to be sure we clarified if that was still going to be a requirement or if that's outside the articulated plan or part of the articulated plan. My other question relates to LPN, so I'll wait till we get to that.
Okay. Thank you. Anyone else have any questions or comments on the sections that Jenny has described at this point? Feel free to raise your hand or send a question. All right, I have a question or a comment from a Cameron K. Garrett. Cameron?
Yes. Am I unmuted? I am unmuted, correct?
You are. Go ahead.
Okay, good, good. It just has to do with the webinar itself. The screen is showing the titles of the law that you're talking about, but it doesn't move, it doesn't scroll down, so we can't stay focused on what's being asked or what's being talked about.
Okay. Jenny, might you be able to help? I think your screen is being shared right now.
Sure. Well, I think what we're because this is early engagement, the screen is showing what the rules are right now. We don't have a drafted red line for you. And there are 135 pages of nursing rules. So that's kind of why we're sticking to the big topics of the changes, if that makes sense. I think being virtual, I think it would be very difficult for us to kind of go back and forth. So, I mean, so I guess what I'm trying to say is you can bear with me. We're trying to just go off of kind of the summary that I gave a few minutes ago when I started and hit those topics and try to kind of keep everybody in their questions surrounding those topics before we move on to a next topic. Now, if there's something that at the end we don't cover that you want to speak to, absolutely, feel free to do that. But this way we can kind of keep it in order, and then we will go back, as Karen had stated, we'll go back and we'll fill in where all the comments go in relation to the current rules, so that when the board gets it, they can clearly see, oh, we had a stakeholder comment based on this particular rule. We need to talk about it and address it and decide whether or not to make changes. Does that make sense?
And Jenny, this is Karen. Yeah, I think that makes perfect sense. And I think that's the intent of early stakeholder. Again, I think with this early engagement, people get tied to wanting to comment on changes that have been made to the rules, but we've not done that yet because we want to get input before we decide what changes to make. And if someone out there does say, if somebody online says, I know that I want to change to say rule 1.8, then if you direct us to that in your comments, we're happy to move the screen to that rule.
Great, thank you, Karen and Jenny. I don't see any other questions or comments at this time.
Okay, the next big topic is the age requirements for volunteer nursing license, that it has been removed. So you no longer have to be 55 or older to be to receive a volunteer nursing license.
All right, I see I have a hand raised, I believe. Let me just find it. Nope, it was lowered. Don't see any requests to speak or any comments via the chat.
Okay. The next two I'm gonna push together if that's okay. It is for the new name of the advanced practice registered nurses as APRNs, and the bill defining collaboration, delegation of patient care, plan of patient care, licensed healthcare provider, and then expanding on the definition of practical nursing.
If anyone has any questions or comments in that area, please raise your hand or send a comment. I see a hand from Colleen Casper. Colleen, I've unmuted your line. There you go.
Thank you again. So on the LPN, it's my understanding it's actually expanding the scope as well as possibly the definition, and it's specific to describing that the LPN, I think the statute reads the LPN may participate in focused assessments, and we'd like to make sure that that includes conducting focused assessment, please.
Okay. Great, thank you.
Thank you. Does anyone else have any comments or questions regarding the areas that Jenny just described? If so, feel free to raise your hand and I can unmute your line, or send a comment or question via that questions box on your webinar screen. Robin Orr. Robin? You're still self-muted? There you go.
Yes, hi, my name is Robin Orr, and I have an expired LPN license that I was looking at reinstating. So I practiced in an intensive care environment in pediatrics in a hospital environment. I would just like to have someone explain a little bit about what was the rule for LPNs prior to the rule changes, and what are just an overview of what the major changes are in the expanded scope of LPNs.
So Robin, you're just looking to get a little bit better explanation regarding what exactly changed regarding the scope of an LPN. Is that correct?
Yes, yes.
Okay.
Particularly as it relates to supervision. I found that it differs in the state of Colorado compared to other states according to a nursing home that I've spoken to recently.
Okay. Jenny, might you be able to address that, or is that something we might have to look into?
That is something for me personally, I will have to definitely look into it because I do not know that off the top of my head. I'm so sorry.
We'll have
So
to
I think
get
that's
back
something that we
with you.
can, yeah, I think it's something we can address offline, and this is kind of more of a personalized or a question that's situational, and we're happy to address those offline. So we can make sure that if you put in the chat your email address, we can make sure and get back to you after the webinar.
Okay, thank you.
Thank you. So go ahead and send your email address via the questions, and we'll have that recorded so we can get back to you. Thank you. Any other comments or questions? Anyone else would like to speak on the areas that we're working on right now? So please raise your hand or send your written comments. I don't see anyone else at this time.
Okay. The next one was the removal of having the requirement that the director of DPO or division director has to consult with the board when appointing an executive administrator, and that a member of the board panel serve on a panel to interview candidates for the position.
We'll give it a minute in case anyone has a comment or question.
Okay. Okay. So I'll move on to the discipline. Oh, do we have somebody? Sorry, started talking.
Nope, sorry. I was just saying we don't have anything at this time, so we can move on to the next one. We can always go back if anyone thinks of something later, so don't have no fear.
All right. Now there are a few updates related to discipline, so if we can go through those separately just to make sure we hear from everybody if there's a comment or concern. The first one is the board can now enter into a confidential agreement with a nurse who has a physical illness, physical condition, behavioral, or mental disorder.
All right, I have a hand raised. Bear with me. Patricia Abbott, go ahead.
Yeah, just in looking at the disciplinary rules, and in particular the comment you just made, or the rule you just read, is this similar across, kind of similar to Karen Zink's question earlier, is this similar across all the practice acts? And then how are you, that's one question. And then my second question is, how are you guys going to define physical or mental illness? I mean, is it high blood pressure? I mean, are there going to be specific criteria as to when the nurse needs to let you know they have a diagnosis?
Thank you, Patricia. Jenny or Karen, can you possibly address her question?
So this is Karen. I mean, the use of physical and mental illness, and Jenny, correct me if I'm wrong, you're talking about the confidential agreements here?
Yes, ma'am.
Yeah.
Yes.
Yes, and that is similar across professions, and this is really meant, this is really something that is quite helpful for the profession. You know, rather than disciplining nurses who may have a physical condition, which could be something like multiple sclerosis, or it could be early Parkinson's that causes tremors, it's meant to have people come forward and be monitored confidentially rather than letting it escalate to a point where they may be disciplined because their illness could cause patient harm. So if that makes sense, the board will certainly make rules surrounding this to describe it. And so if you have any suggestions, now would be the time to provide that input.
Well, as a behavioral health, I mean, as a provider, I see many patients who are on antidepressants for mild anxiety, you know, depression. And so at what point as providers, or would the nurse need to tell the board? I think it's just a big topic. And, you know, if somebody has hypertension on the physical health side, do they need to let the board know? So I think talking with my colleagues, that's the big question there.
Yeah, I think your point is taken, but I think the important thing to remember is that someone has a physical or mental or behavioral issue that impacts their practice, right? So, you know, if I have high blood pressure, and I take high blood pressure medicine, and with that I'm normal, you know, my blood pressure is normalized, I don't have symptoms, it doesn't cause issues. That's different than if I suffer hypertension that isn't controlled with medication and I black out, right? So I think we can make the rules, but I think also it's looking at the intent of the law.
Right, and I think that's, you know, people who actually have a colleague that has kind of early MS, and she said, well, what I need to tell them, I have no symptoms, I just have the diagnosis, I'm taking the meds, it doesn't impact my practice. So I think that people are concerned about which diagnoses in particular you're interested in. So anyway, that's probably a long discussion, and I don't imagine you guys will be putting out a list, but I think the important takeaway as I'm hearing it, does it impact your practice? And that would be in the perspective of the nurse.
Right, it'll be clarified in the rule, but definitely we'll talk about whether or not it impacts your practice or is likely to impact your practice.
Versus could potentially impact your practice.
Yes.
Perfect, thank you.
Thank you. I have another hand raised. Let me navigate there. Leanne Laskowski. Leanne, you're unmuted on my end. Leanne?
And I'm unmuted on mine. And to tag on to, I think it was Patricia's comment about, I don't currently have any chronic conditions, but the rule will address whether it impacts your practice, because I know in filling out applications for jobs, they always ask if you have any physical or mental impact that could impact issues that could impact your job or your function at this job. So is it going to be specifically that? I'm just from a perspective of personal HIPAA protections, you know, we have to protect all of our patients' information. Is ours going to be protected as well?
And I think that's the purpose of the confidential agreement. Again, I think thinking back to the board's previous ability to discipline someone who has a physical or mental issue that impacts safety. What this is trying to do is to say to nurses, if you have something like MS, we're not saying that you can't practice, but you may need to alter your practice. You might need to work shorter shifts. You might need to not work night shifts. And that's dependent on what, you know, a physician or the peer health provider recommends. But if you come to the board with that early and get a confidential agreement, you're not risking potentially being disciplined when something goes awry. And so I think that if you think about the confidential agreements, it's all about protecting the nurse's information and making sure that they're safe to practice without that then becoming a public disciplinary issue.
Okay, thank you for that explanation, Karen. Patricia, looks like you might have a follow-up. Patricia?
Oh, sorry.
Go ahead.
So the organization that I guess I'm representing they had grave concern with the word discipline for physical illness. And that's what my question was. The one before I came, they had me ask specific questions. And that's what one of our thoughts was, is this across all health professions that a professional is disciplined for having a physical illness? You know, and it kind of goes back to my diabetes is very well controlled, and then one day it's not. Am I going to be disciplined because I didn't tell people I have diabetes? And so I think that was kind of the nuances that they were concerned with, was the word discipline.
Right, and I think what you're looking at is I think you're looking at the changes, but you're not looking at how the law was before. So
Well,
basically as the law was before the change, you could have been disciplined if you passed out during a procedure because of your diabetes, right? Now what this is saying is, if you know that you have this health issue and you know that it is likely to impact your practice, or it is a high probability it could impact your practice, you can disclose that to the board, and you can be part of a confidential agreement that no one else knows about to make sure that your practice is safe, so that you don't face discipline. And then again, the confidential agreements are in most healthcare professions. They're in the Practice Act, and the physical health piece is in most healthcare professions in their disciplinary practice acts.
Okay, and then I think that the organization I represent was concerned that peer review had direct ties to the Board of Nursing and to DORA, and they did not feel it would be necessarily an unbiased approach. I think physicians use safe harbor, and then also, you know, so I think that they were just concerned with the confidentiality, and then just as an advanced practice nurse practitioner in a Board of Nursing ruling, it's hard for me to hear that a physician or a peer review would make determinations on one's health status. And at least in our profession, we should be inclusive of nurse practitioner providers. That's just a side comment. That's me, not my organization.
Sure. So I think it's important to know that it's not peer review; it's peer assistance.
I do. Okay.
And so it's not a group of physicians. It's actually a group of healthcare practitioners that are working with the nurse, with the licensee on their health conditions.
Are nurse practitioners on this board or on the peer assistance?
It's not a board, it's peer assistance services, and I don't know exactly who they employ, but they employ a wide range of healthcare professionals, behavioral health, physical health, and then they also do allow the people in peer assistance to see their own healthcare provider,
which could be a nurse practitioner or a physician assistant.
It can be whoever the nurse sees for their physical health.
Okay, perfect. And then, so I think the organization did want to know who is on the peer assistance that would be determining the future of their positions.
So I think it might be helpful if you share what organization you represent. And then secondly, it's Peer Assistance Services, PAS Incorporated, and that can be looked up. That can be looked up online. That's who holds the peer assistance contract for nurses.
Peer Assistance Incorporated, you said?
Peer Assistance Services Incorporated.
Got it. I will give them this information.
Okay, thank you. We had a question that was submitted in written form from Juan Peterson. It's she or he, my apologies, says Colorado is an independent state for APRN practice. Are we going backwards to collaborative state? I'm not sure if you'd like to clarify your question at all. I can unmute your line if you would like. If you'd like me to do that, feel free to just raise your hand. Otherwise, your question, I'm not sure if Jenny, you or, we were with the hand raised. Maybe the person can explain a little bit more. Go ahead.
So when we look at every state, Colorado is under independent state for APRN practice. And I just heard that you mentioned about collaborative practice. Are we going backward like 10 years ago?
Okay, Jenny, might you be able to address that?
This is Karen. There's no change from a nurse practitioner's independent practice. In Colorado, nurse practitioners work independently.
Okay, good. I'm glad to know that because I was concerned that we're going back 10 years ago, that we were collaborative state. Okay, thank you.
Okay, thank you. All right. Does anyone else have any questions or comments at this time regarding anything we've talked about so far? I don't see any other hands raised or written comments right now.
Okay. All right. I will put the next two together. Malpractice insurance companies are now required to notify the board of any malpractice claims against a licensed nurse. And nurses must now report a conviction of a crime within 30 days instead of 45 days.
Okay, thank you. And feel free to raise your hand, please, if you'd like to speak about either of those items, or send your written comment or question via the questions pane. I don't see anything right now. We can always circle back if I see something though.
Okay. The next one is the bill modifies the grounds for discipline related to drug and alcohol use, diversion of controlled substances, failing to report certain actions, failure to act within limitations created by a physical or mental illness, failing to comply to limitations agreed to under a confidential agreement, and engaging in a sexual act with a patient during the course of care or within 6 months. I know we heard a couple comments on that last one already, but if there's anything on the other ones.
I don't see any hands raised right now, and I don't have any comments. I can let you know if you receive anything.
Thank you. All right, so then we'll move into the nurse aides. And there are 3 big changes to the nurse aides. We'll take them individually. First, after a certificate is revoked, the waiting period for certification or for recertification is now 2 years.
No questions or comments at this time.
Okay. Second, if deemed competent by a registered nurse, CNAs may now expand their scope so that they can change ostomy bags, administer oxygen, and place medication in a minor patient's mouth if the medication was pre-sorted by the minor's parent or guardian.
Okay, I have a hand raised. Let me navigate there. Tammy Mars.
Yes, my name is Tammy Mars, and I'm from Colorado Springs. With that, the minor that gives medication that is poured by the parent, is that just for the home health? Would that also be if the CNA worked in a assisted, well, not assisted, but in a hospital or something like that, or assisted living or something, or is it just the 16 or 17-year-old that can give meds as a home health CNA? And with that, does that also work with the temporary license?
Thank you, Tammy. Do you have a suggestion one way or the other on those questions you just posed, or are you just looking for the board to clarify one way or the other?
Yeah, just to clarify, I understand it's probably the home health, but with that, now that Pearson VUE is not testing, can they still do that with a temporary license, and the temporary license stating that there has to be an RN on duty?
So this is Karen. I can answer the questions about the temporary license. The temporary license requires that they be directly supervised.
Right.
So that doesn't change.
But with the home health, with home health, they are not, the RN is not directly there with them at the home. They are with phone call away, but they are not directly there. So how can this go in effect if they can't use their temporary license to do this?
Well, so what I'm saying is that the temporary licensee has to be supervised by an RN. That's the law. So yeah, I'm not going to talk specific circumstances or special circumstances. What I will tell you is that whoever holds a temporary license can practice within the full scope of that license. However, they have to be supervised.
Yeah, I understand that, but they cannot be supervised at home health. The RN is not there to supervise them.
I understand that that may be a hurdle and something that, you know, we can take to the board and take under advisement, but I understand that maybe the home health might not be the best place for the temporary licensees to work if they can't be supervised.
Okay, thank you.
Thank you. I have a hand raised. Bear with me. Deanna McCoy. Deanna McCoy, my apologies. You're still self-muted. If you'd like to speak, go ahead and unmute your phone or computer.
Okay, got it. Thank you. I just wanted some clarification on administering oxygen. As a doctor's order for oxygen, this might be more broadly applied as initiating oxygen, adjusting flow rate, and so forth. So I just wondered what the clarification will be on that. Does it mean turning it on, off, putting cannulas or masks on? What does this specifically mean?
Okay, I think that's something that the board would be able to possibly clarify.
Right, that's something that we'll send to the board for clarification.
Absolutely.
Thank you. I had a written comment sent from Mary Watson. I believe this is in reference to the conversation regarding the Cna Supervision, but please correct me if I'm wrong, Ms. Watson. She says available by phone call has been defined as supervision, though. Mary, if you'd like to clarify that more, feel free. I can unmute you. Feel free to raise your hand if you have. If you'd like to clarify that comment more. Don't see your hand raised, so that is something that we can provide to the board as a comment. Thank you. anyone else have any comments or questions regarding the sections that we've discussed so far? Feel free to raise your hand when I can unmute you or send your written comments or questions. Nothing at this time.
Okay, and the very last thing regarding CNAs is the bill clarifies the regulation of a certified nurse aide does not apply to a person directly employed by a medical facility for the first 4 months of practice if the employment is part of an approved training program and the certification is not through endorsement.
All right, I had some further follow-up from Ms. Watson. She stated, I believe that was the outcome of our last meeting. Home health agencies may employ T-NA if they are supervised with a nurse on call. Perhaps I'm incorrect. Thank you for your clarification. Again, that will be provided to the board so they can take it under advisement. I don't see any other hands raised or any other written comments.
Okay, well, that is all the high points. I just wanted to go back over the fact that the board is scheduled to meet on the 19th. At that point, they will review red line changes that we are currently working on in corporate, and we'll see all comments that you have made today, and they will get a copy of the recording as well. And there will be 2 more stakeholder meetings, and that will be posted as soon as we have them verified on our website in early September and then early October. And then rulemaking hearing will occur on October 28th.
Jenny, this is Karen. I just want to make sure that you just open it wide open if anybody has any other commentary they want to make on changes they'd like to see in the rules.
Oh, yes, ma'am. Sorry, I meant to go back to that. Yeah, so clearly, I mean, those were just the high points. If there's anything that anyone else wants to raise, has comments about, has questions about, absolutely, you can do that at this time. So we'll open it up to the floor.
Okay. Robin Orr had a follow-up. I think it would be wise to change the word direct supervision to direct and/or remote supervision. And then she provided her email for follow-up regarding her LPN question. So thank you for your comment, Robin. If you would like to clarify that further, feel free to raise your hand and I can unmute you. Anybody else has any comments about anything? Feel free to raise your hand. Robin, you're unmuted. Go ahead.
Yes, just a follow-up on the other commenters' information. I think it's a very serious problem for home health care all across Colorado, that there is this requirement for an RN to be present with a nurse aide or an LPN, when the nurse aides and the LPNs traditionally conduct their home health care under the orders of a nurse or a doctor and are always available by phone, and this is how it's done. It really changes the situation to only those who are in a hospital rather than home health care. So I think that it's normal, even on a floor in a hospital, an LPN is under the supervision of an RN, but she may be in the other room down the hall. So
Yeah.
I think that there's got to be some clarification on what it means what supervision means. And I did speak to someone who said that Colorado's laws on this are very different from other states. And so as a result, there were only advertisements for 3 positions in Colorado for LPNs. So it really it really impacts the LPN licensing.
So I think we might be talking about two separate things. When we're talking about the temporary license, is that what you're talking about? The supervision of temporary licensees?
From what I understand, that's currently the law for all licensees in Colorado in comparison to the other states. And that the question that the other woman had about temporary was also an issue.
So my comments about the temporary licenses are that we have a huge population right now of nurses and CNAs who have a temporary license because they've been unable to test. So we have some that have been unable to take their written test. We have some that have been able to take their skills tests. And so requiring supervision of someone who has been unable to date to demonstrate their competency is something that's really a matter of public protection, right? The state went ahead and said, even though you can't test, we're going to go ahead and give you this temporary license because we want you to be able to get out into the workforce. But we have to have guardrails in place to make sure that patients are safe.
Oh, I agree with that 100%.
Right.
But I do think that the RNs and the doctors who hire that individual should be able to make that determination of what that person is capable of. And they are available by video and by phone. So what it means is, you know, an RN is not going to do home health care. They're just never there. I know that from my mother. So it cuts out home health care. In other words, I think that whole issue has to be looked at more closely into how it actually operates and who is supervising whom, because the person is not without supervision just because they're there alone with the individual. Do you know what I mean? Also, the way I read the law, the way you had it written, it sounded to me like someone who has a temporary license can't even give a bed bath without an RN being right there by the bed, which is just not going to happen, even in a hospital setting. So I think you know, this whole issue of supervision needs to be looked at very closely, I think.
Okay, thank you for your comment. We have some follow-up via the chat. Mary Watson has stated, excellent point. We all know hospital CNAs are extremely unlikely to ever give a med pre-sorted to quiet patients. That only happens in home health. And then a Molly McDonald Waldron stated, will there be any clarification related to the AHCA temporary CNA training program, 8 hours, to address the emergency shortage? How will these CNAs be affected when the shortage is over, and are they allowed to continue to practice? You can repeat either of those if Jenny or Karen, you have thoughts or need more information on those.
Can you repeat the second one, please?
Sure. Will there be any clarification related to the AHCA temporary CNA training program to address the emergency shortage, noting that the program is 8 hours? And then how will these CNAs be affected when the shortage is over, and are they allowed to continue to practice?
So I think that that's something that that will be addressed. Obviously, it's not addressed through the sunset, and that's why I want to be really careful that we're separating out the issues. So today we're here to talk about the changes for the sunset, the emergency rules that are in place during the pandemic. Those are separate. Those are promulgated by the director. I'm certainly going to take those comments back to her. We have had stakeholder meetings specifically directed toward that. At this point, CNAs are required to undergo the education that's required by the Nursing Board, the Nurse Practice Act. And that doesn't include an 8-hour course. And as far as the people who have temporary licenses, they will hold those licenses until they are able to test. I understand that there's still not able to do the skills portion, but I do understand that test sites are opened up and are able to facilitate more test takers for the written portion. And so I think that's something that will probably be addressed in the next set of emergency rules, is trying to get the people out there who can sit for their written exam to get that done, because that's certainly helpful to get things moving along.
Okay, thank you, Karen. Molly or Mary Watson, if you have follow-up on your comment based on Karen's response, please let us know. I have a written comment from Jean Martin. Jean Martin with Copic. We get a lot of questions regarding delegation. The language on page 7 of House Bill 2012-16 is pretty broadly written. It would be helpful to flesh this out in rules. For example, a PA provides delegated medical services, but they could also delegate. We'll follow any draft proposed rules. Thank you.
Okay, we'll take that feedback to the board. We can take that feedback to the board. And I see a question up here, is there proposed language available to react to? Again, just for people who may have joined later, this is what we call early stakeholder engagement. So we want to get your thoughts and your input before the board sits down to draft revisions to the rules. So there's no proposed language yet, but that's why we're here trying to get feedback so the board can consider all of your input when it makes decisions and it puts out a draft copy of the rules.
Okay, thanks for clarifying that. The written comment from Patricia Cook. Any changed language could be provided to protective oversight, which is used in the CDPHE rules for the different entities. That would mean the aide would check in along with the EVR and home health to verify the care real time. Thank you for that comment, Patricia. If anyone who's in a written comment wants to further clarify over your audio, please let me know by using the raise your hand feature, and we can go ahead and unmute you if you want to further clarify any of your comments. Otherwise, your written comments will be provided to the board. Any other questions or comments at this time? Feel free to raise your hand, and you can unmute your line, or go ahead and send your comment or question via the questions pane. Not seeing anything at the moment. I don't know if we want to give it another minute or two. All right, I don't see any further questions or comments. Happy to hold on if you would like us to wait further. Otherwise, I'm not sure the next steps are. Jenny or Elena might be able to help with that.
Yes, this is Elena. So in closing, thank you for participating in today's stakeholder meeting. The stakeholder comments and program recommendations will be presented to the board prior to the formal rulemaking hearing, which is once again tentatively scheduled for October 28th. In addition, the Board of Nursing is, like Jenny was talking about earlier, going to hold 2 additional stakeholder meetings. So licensees and stakeholders will receive notification in the next coming weeks regarding those meetings. The second one will be on, just to clarify, it'll be on September 4th. And then the third stakeholder meeting will be on October 9th. So do look out for those notifications. And at the additional stakeholder meetings, we will have draft rules that people can comment on, and that might be a little more helpful for you. So yes, thank you again, and we are going to end the webinar.
Elena, one quick thing. Is there an email address if people want to send written comments?
Oh, absolutely. Sorry. If you do want to provide written comments, the email address for that is Dora_DPO_rulemaking@state.co.us. And that's also on the notice, that email address. Is there?
Thank you. We have a question regarding that. Thank you.
Oh, absolutely. All right. Everyone have a good afternoon.
Thank you.